and a warm welcome to everyone here in our virtual space. Good afternoon, and thank you for attending today's Lunch and Learn event. This is the first of our fall series, and for me, a particularly poignant topic that has been covered in the media quite a bit in the past month as it relates to educational equity. The PHRC has had the pleasure of working with our featured speaker, Kristina Moon, and her organization, the Education Law Center of Pennsylvania, on several events and initiatives. We have been afforded the opportunity to have her, as well as some of her colleagues, speak on PHRC panels and provide their expertise on many issues related to discrimination here in the Commonwealth. We are eager to have her here today and provide some clarity and much needed information around educational equity here in the Commonwealth. So without further ado, I'd like to read a snippet of her impressive bio and then turn the virtual floor over to her. Kristina Moon uses the pronouns she and her, is a senior staff attorney in the Philadelphia office of Education Law Center, PA. She advocates for students and families through impact litigation, individual representation, and policy advocacy on a variety of education concerns. Ms. Moon's work includes ELC's campaign for inclusive schools and honest education, a statewide school funding lawsuit, as well as litigation and advocacy on behalf of English learners, LGBTQ+ youth, and students in the foster care and juvenile justice systems. Previously, she worked at Prisoners Legal Services of New York and Detchert LLP. Ms. Moon is a graduate of Temple University Beasley School of Law and Franklin and Marshall College. It is my pleasure to turn the virtual floor over to Attorney Moon.
Thank you so much, Director Chang, and thank you to the PHRC broadly for the opportunity to share information in this format and for our continued collaborations, as Director Chang mentioned, to ensure the civil rights of students across Pennsylvania. I'm going to take just a moment to make sure I can share slides.
Looks good.
Okay, so as mentioned, we're going to talk today about the Title IX. I think the mailing said controversy. I think I might call it a debate, but really, I hope that by the end of this presentation, there will be no confusion, controversy, or debate, and there'll be more clarity about what the status is of the 2024 Title IX rules, their application to some schools in Pennsylvania, based on a injunction following a federal district court decision out of Kansas, and the parallel and continuing obligations for non-discrimination that exist for all schools in Pennsylvania under the Pennsylvania Human Relations Act. I believe we're going to try to have time at the end for questions, but folks can put them in the chat or follow other directions from the host about where to share questions. And I will provide these slides to all the registrants afterward. No worries about that. And in fact, I try to make the slides a little more text heavy than probably presenters should, because I know that they can be a resource for folks after the presentation. So as I mentioned, a little bit about ELC, we'll talk about Title IX, the rule, the Kansas case injunction, and the Pennsylvania Human Relations Act. I also have a number of slides, if time permits, to share about issues that we see presenting for trans and gender diverse students in schools across Pennsylvania and nationally, and the relevant case law about those situations, if we have time. And again, if not, they'll be shared by materials with the materials to the registrants afterward. So if anybody doesn't know about Education Law Center of Pennsylvania, we are a legal services nonprofit. Our mission is to ensure access to a quality public education for all students in Pennsylvania. We have offices here where I sit in Philadelphia and in Pittsburgh, but we really respond to requests for assistance and provide services statewide. So you can do that by calling our helpline, and I'll have that contact information in the last slide of the presentation. And we also work regularly with partners and other coalitions across the state to respond in varied ways to really all issues that could present for students in public schools. We talk about equal access, adequate and equitable school funding, and school climate issues, including school discipline and dismantling the school to prison pipeline. We try to focus our work on those students most underserved historically and currently, those students who are marginalized, including children living in poverty, children of color, those with disabilities, those with experience in foster care or juvenile justice systems, experiencing homelessness, those who speak languages other than English, and those who are LGBTQ and gender diverse students. And of course, we understand our students, like all people, have multiple identities. And so we do work at the intersection of all those identities as well. And just a orientation for conversations about LGBTQ students, real foundational orientation for Education Law Center. And I know PHRC and other advocates we work with as well. But we think this is important for everyone to understand and talk about because school efforts to affirm and support students are, in fact, life-saving. Unfortunately, we hear through our helpline and partners and directly from parents all the time and students about hostile environments for LGBTQ students in schools across Pennsylvania, where they face harassing comments that are not interrupted and prevented by school staff. They face policies like those we'll talk about in this presentation that are facially directly discriminatory based on gender identity. And all of that can have a very negative impact on school attendance, on their ability to concentrate and achieve in school, and their, well-being and life outcomes, really. And we know that the Third Circuit and other courts have recognized that trans students face this kind of discrimination, and that schools have a compelling interest in shielding them from that discrimination. So importantly, we recognize that in addition to all of the negative outcomes that can come from discriminatory contexts, actually having affirming school places, it does the opposite, actually really saves lives. Research shows that LGBTQ young people reported having access to at least one space that was affirming reduced their odds of attempting to die by suicide by 35%. And just using a student's correct name and pronoun decreased thoughts of dying by suicide by 29% and attempts to die by suicide by 56%. So just recognizing students' dignity, humanity, their respecting their identity by using correct name and pronoun can have profound effect on students' experience and certainly their ability to concentrate and learn in school. So I know that this being a public webinar opportunity, we've got folks with legal background and those without. So I'm going to try to cover a variety of contexts that folks may be coming with prior experience or not in here. When I talk about Title IX, that is a federal statute, federal law that protects people from discrimination based on sex in education programs or activities that receive federal financial assistance. This applies to all public schools, which includes charter schools, and also approved private schools where a student might be placed from their district catchment school based on their IEP. It can cover a variety of contexts, including those listed here: sexual harassment, athletic opportunities, sex-based discrimination in particular courses or programs, treatment of pregnant and parenting students, treatment of LGBTQ students, discriminatory discipline, or hostile environment. And there is, as we said, Title IX, the statute, the federal law, and there's also regulations that are I should flag for folks that aren't familiar, regulations and rules in this context mean the same thing. So I use them interchangeably. Others in this space talk about regs, regulations, or rules, means the same thing. And they are the guidance issued from the Department of Education, the Federal Department of Education, which has the responsibility under law to implement and enforce Title IX. So we've got Title IX, the statute, and Title IX regulations that provide guidance about that statute. We also, of course, have case law, which is, decisions from a particular court that's presented with a particular fact pattern, where a student in this context would come forward and say, I've been discriminated against based on sex, and the court makes a decision on those particular facts, and that then is applied as an example, or in some cases based on jurisdiction, a binding rule about how future cases should be applied or understood. So Title IX, the statute, Title IX regulations or rules, and case law, all relevant and play different roles in this context. This timeline here references the path of regulations under Title IX. There have been prior, of course, but reference here to 2020 final regulations under the Trump administration. We also had in 2022 proposed regulations under the Biden administration. Those received over 200,000 comments from the public, and that was closed in September 22. We also had a separate proposed rule about sex-based distinctions in athletics for schools in 23. That received something like 150,000 comments and was closed in May 23. We waited a long time and finally have received the final 2024 rule published in April 2024. Shortly thereafter, we saw lawsuits across the country challenging the 2024 rule, and those courts have implemented injunctions, which is a pause, a ban, to say this rule can't go into effect in particular jurisdictions or contexts where the court has jurisdiction. So we'll get into more detail as that applies to Pennsylvania. And that rule, the 2024 rule, had an effective date of August 1, 2024, so for the start of this current school year. So these 2024 Title IX regulations, I think about them in kind of three main bucket areas: those affecting LGBTQ students, those relating to pregnant and parenting students, and then due process protections, which relate to how a school has to provide notice about students' rights under Title IX, how they have to receive complaints, process complaints, investigate, and the whole process for following through on a complaint to resolution. The broad definition change or shift to, as the Department of Ed said, confirm and bring into alignment with case law that had previously been considering Title IX. These 24 regs say that sex discrimination includes discrimination on the basis of sex stereotypes, characteristics, pregnancy or related conditions, sexual orientation, and gender identity. And that expanded or clarifying definition was really intended to shift the focus from a narrow sexual harassment basis to broader sex-based harassment and discrimination. Relating specifically to LGBTQ students, again, that redefinition of sexual harassment as sex-based harassment, or to sex-based harassment and discrimination, is intended and encompasses the broader range of prohibited conduct that impacts LGBTQ youth. And because it now explicitly includes discrimination on the basis of gender identity, orientation, sex characteristics, that means that schools must address anti-LGBTQ harassment. They are more clearly and explicitly responsible, obligated to address harassment and discrimination facing LGBTQ students. With regard to gender identity, the rules specify that schools must allow students to participate in classes and activities and use bathrooms and locker rooms and dress and groom themselves consistent with their gender identity. So their rule requires access to sex-separate facilities in a way that does not cause more than de minimis harm, which is a legal term. But the rule is clear that, as an example, a definition, denying students access to facilities that align with their gender identity is more than de minimis harm and would be prohibited by Title IX. In the context of uniforms, students have to be allowed to wear a uniform that aligns with their gender identity, not any distinctions based on sex assigned at birth, for example. If schools have uniforms separated by sex, girls must wear X, boys must wear Y. Those are not recommended or appropriate in lots of contexts and could maybe be a different presentation. But if there is a uniform that distinguishes based on sex, schools have to allow children to dress based on that which aligns with their gender identity. In the context of a student's name and pronoun use and respect in school, the language in the commentary from the Department of Ed with these regulations says that, this is harassment is a really fact-specific characterization, but recognizes there's case law cited elsewhere in this presentation as well that harassment based on refusing to use consistently and persistently refusing to use a person's gender identity in their name and pronoun, it can be considered harassment under federal anti-discrimination law. So that is a brief highlight about what the 2024 Title IX rule says and does that is a change or update. Now I'm going to talk about the legal challenges that were brought to that rule. So there are 8 lawsuits that have been initiated by other states to prevent the 24 final regulations from taking effect. Courts in each of those cases have issued an injunction on the entire rule, and that means the rule is enjoined in 26 states. Pennsylvania is not a party to any of those lawsuits challenging the 24 final regs directly. And in fact, Pennsylvania's Attorney General filed an amicus brief in the Kansas case we'll talk about, supporting the 24 rule and students' rights under the law. There's no universal injunction. This is a legal term that's used to reference an order from a particular court that applies to the whole country. There's not one of those in effect. How Pennsylvania comes into play is that a case arising out of Kansas was brought by particular states in addition to organizations, and those organizations members in any state in the country are entitled to benefit of the injunction. So we'll get into that in detail. But you should also know that all of these lawsuits challenging the Title IX rule and the injunctions that were ordered out of those challenges have been appealed by the Department of Ed in each of those cases. So they're sitting now in the circuit courts of appeal. There was an attempt to get U.S. Supreme Court intervention earlier before those appeals run their course, but the U.S. Supreme Court denied that kind of emergency request for relief. And that request for relief was based on this one element. I've noted here that the rule is enjoined in entirety in each of these cases, and that references back to, you remember, I said there are kind of 3 buckets of areas affected by the rule: LGBTQ students, pregnant parenting students, and due process protections. All of these challenges really focus on the gender identity element affecting LGBTQ students. Really entirely, their focus of the challenge is the gender identity provision. And yet, each of these orders coming out of the challenges enjoin the whole rule. So not focusing on only the gender identity that was challenged, but also the provisions relating to pregnant parenting students and also the provisions about the due process protections. Okay, the case Kansas and other states versus the U.S. Department of Education was brought by the states listed here, and also the national organizations Moms for Liberty, which is a conservative organization active in school board politics across the country, Young America's Foundation, which focuses at colleges and universities, and Female Athletes United, another advocacy organization. This case, the court issued an injunction in, again, the whole rule in its entirety, all of the issues presented for the plaintiff states that brought the case, and also the organizational plaintiffs, including Moms for Liberty, which is active in the K-12 school space. So for Pennsylvania, this rule means that the U.S. Department of Education cannot enforce the 2024 Title IX rule in individual public schools that have students attending where their parents are members of Moms for Liberty. And there is a list of these schools that's submitted to the court and updated in the materials that ELC provides. And also there's a link on the Department of Ed's page. That was appealed. As I said, all of them have been. And it's important to look actually at the language of the decision, which is highlighted in an excerpt here on the left side of the page. As it says explicitly, the Kansas decision does not have any effect whatsoever on state laws. The Pennsylvania Human Relations Act and its regs prohibit discrimination in schools based on gender identity and expression, and sexual orientation and pregnancy, parallel to the Title IX protections, but separate and unaffected by this Kansas case decision. So all public schools, including charter schools, remain liable under these provisions of the PHRA to prevent discrimination against LGBTQ students and pregnant students. We also have pre-existing case law in the Third Circuit relating to the rights of trans students. And this rule, this decision really, again, doesn't require schools to make any changes to their policies, whether they have supportive policies or discriminatory policies already. Doesn't require them to change. And it doesn't have any effect on that case law. Remember, we talked about Title IX, the statute and regulations. There's also case law separate from the regulations that are interpreting Title IX law itself. That still stands. The Kansas case has nothing to do with it. So it's really important, and our public education campaign here is to make sure that schools and parents really understand the very narrow application of the Kansas case, which is that only affects the U.S. Department of Education were it to receive a complaint from a student in one of these affected listed schools that says, I've been discriminated against based on gender identity. The U.S. Department of Education can't apply their investigation to that complaint using the 24 rule. They can still apply Title IX. They can still apply case law under Title IX, but only the 24 rule can't be applied to that particular complaint that came out of a school listed on the injunction Moms for Liberty list. So the procedural history of that case, again, that injunction was ordered July 2, and since then, there have been multiple filings on the public docket, identifying a total of, at this stage, 509 Pennsylvania schools, individual schools, across 160 school districts and 4 charter schools. This is clear from the court that this list is unfortunately going to keep changing and updating because there's no order of final deadline. Future members of Moms for Liberty that submit themselves to the National Moms for Liberty organization and ask to be listed in this injunction can. So, we're hearing that it creates a real area of confusion and kind of constant potential change for schools to understand if they are subject to this injunction. And that's really unfortunate. And, there is also nothing that we can do about it. We've gotten some questions, well, how do I get off this list if my school has been put on this list. There's nothing for individuals to do about that. The United States Department of Education has appealed the order, and that's the process that we'll try to amend it or reverse it. There's nothing for individuals in our schools to do in terms of getting you off the list. There has been further progression of the case. There's summary judgment briefing happening. And I think, that'll progress through the fall. So while there, as I said, is confusion, understandably, about whether you're on this list and whether that changes as time goes on, remember that it does not actually materially change the school's obligations to students because we have the parallel obligations under the Pennsylvania Human Relations Act. So in these contexts, if you're on the Kansas case Moms for Liberty list and joining the 24 rule from your school regarding LGBTQ student rights and pregnant student rights, you would look to Title IX in the case law that pre-existed the 24 rule, and any specifics from the 2020 rule that predated the 24 rule, and also the PHRA requirements. Regarding due process protections, that third bucket that I mentioned under the 24 rule, we can look to Title IX itself and case law and the 2020 rules. Unfortunately, for what I think are very good and helpful protections in the 24 rule on due process proceedings, there's no parallel in our state law for those specifics. So those are without a parallel, the way that LGBTQ, gender identity, and pregnant parenting student rights do have a parallel in state law. So, said again in a different way, the key takeaway from the Kansas case is that Pennsylvania schools have the same obligations to non-discrimination for LGBTQ students under state law, the Pennsylvania Human Relations Act. So a school on the Kansas Moms for Liberty list is still legally responsible to prevent discrimination and provide equitable access to education based on gender identity, sexual orientation, and pregnant and parenting status. Parents and students can submit complaints to the PHRC if a student experiences discrimination on those bases. I'm going to shift then to share more about the PA Human Relations Act. And, I know there's continuing programming from the PHRC on this, their area of expertise and their enforcement authority. So for sure, additional materials look to the PHRC. But for folks that aren't familiar and coming to this for the first time, as I said, the Act prohibits discrimination in public K-12 schools, which are considered a public accommodation on the basis of a number of protected categories. We've been talking about sex, and that includes gender identity, expression, sexual orientation, pregnancy, and birth and breastfeeding. It also includes race, which under the new regs includes hair texture and protective hairstyles, color, religion, ancestry, national origin, and disability. And important to note that generally Pennsylvania courts have construed these parallel provisions of the PHRA to be coextensive with their federal counterparts. So that means that cases that interpret the Title IX law, the federal prohibition on sex discrimination in schools, are used by Pennsylvania courts to understand and apply similar analysis to discrimination brought under the PHRA for sex discrimination in schools. Specifically on sex discrimination, we know from the PHRC and their great messaging materials that we have the newer regulations that have explicitly said discrimination based on sex includes sexual orientation, gender identity, pregnancy, childbirth, and breastfeeding. We also know from statements that PHRC has put out trying to help folks understand, like that in January 2023 about monitoring LGBTQ concerns out of a particular district like Central Bucks. And most recently in July, a statement with the Pennsylvania Attorney General about the limited application of the Kansas decision and the PHRA's continuing application and protection for students in Pennsylvania schools. There's not been as much case law and development of the PHRA of the PHRA in state courts, the way that there's lots of cases applying and interpreting particular fact patterns under Title IX. But we do have some to look to as an example and instructive about how courts would interpret claims based under the PHRA. And one of those is this 2018 case about a student in the school district of Philadelphia that was subject to really horrible peer harassment due to their gender presentation. And the school district was held responsible under the PHRA for not intervening and correcting that harassment. And there was a very significant damages award as well as attorney fee award, trying to show school districts. I mentioned those things, trying to show school districts that there is real liability if you don't respect students' civil rights. Again, there's materials from PHRC themselves about this, but Education Law Center also sharing these presentations with folks, trying to make folks aware some of the basics here about how to file a complaint with the PHRC. You want to be aware of the time period, filing within 180 calendar days of the last act of discrimination. And there is, some what we call room to describe why you wouldn't have been able to file within that period. So don't be turned off entirely. We're happy to get calls from folks to talk through whether something applies or could be within the time period. It has to be filed by someone who's experienced the discrimination. Attorney is not required. We give some advice, but it's not required to have an attorney on your complaint. There's a format here to submit online. You can also work with folks out of their offices and email. I try to make it as easy and accessible as possible, which we appreciate. A listing here of complaint requirements, the basics, really, I think it's a pretty simple and straightforward form. We really appreciate that when talking and supporting with parents. And then this graphic is, I think, from PHRC's materials themselves, about how it's processed, how it's served to the respondent, which means the institution or entity accused of discrimination, so the school in these contexts. You get a contact from PHRC. It's investigated. If you're within the parameters for eligible complaints, and you can, see here some of the possible results of investigation and settlement. Important to note that if you don't get a resolution within 1 year after filing, then you get what we call a right to sue letter, and that gives you kind of authority under the law to bring your complaint in state court. I see. I want to pause to check in with our hosts. I've got slides that further walk through some of the issues that are presented for students in schools and some of the federal case law about those contexts. But maybe we should pause to see if there are any questions about the Title IX rule and the Kansas case and PHRA's application before I take time to do any of that.
Certainly. We did have one question in the chat, Kristina. David Moore asked, is there any indication from the 10th Circuit as to when they may issue a ruling on the injunction from the district court?
I wish that there were regular timelines provided, but we don't get those, unfortunately, too often in litigation. So maybe others are more confident about waging a guess, but we don't have a particular timeline. We hope that it's processed with some haste, because obviously there's a lot of school year running while they are processing.
That is the only question at this time.
I'm going to pause just a moment. Does anybody else have other questions relating to the 2024 rule or the Kansas injunction?
Yes, they will, Nikita.
Okay. Well, then I will share again and go through.
While you're doing that, Attorney Moon, and feel free to share your screen in the meantime, your colleague, Attorney Joki, asked if you could give some examples of protected gender presentation and expression.
Oh, yeah. Thank you for the prompt. So it really can be anything. It can be, we may be useful to hear about types of harassment or discrimination that we hear from folks. So, comments about like your dress, your hairstyle, the way that you act, the way that you speak. It really is very broad. One's identity and expression is the entire way that you move through the world. So any kind of harassing comments or discrimination that suggests you're not doing it the way that a girl should or that a boy should, it's very broad.
Yeah, I'm not seeing any other questions. So if you want to move on to the federal content, we do have time.
Okay. And are you seeing my slide now?
I am not.
Okay. Sept. Try again. Sorry, folks. One moment.
While Attorney Moon is doing that, I just want to turn everyone's attention to the chat. Director of Communications, Director Brothman, did share our updated education protections infographic as well.
That's great. And the other context, of course, that folks should be aware of in the education space is that the PHRC took comments recently about guidance relating to investigation of harassment complaints in schools. So we really appreciate that process and expect those will be shared as soon as possible. That'll be wonderful to have for the field. My Teams has frozen, so I'm not able to share.
If you'd like to email it to me, I'm happy to present on your behalf.
Yeah. Also, let me do that. And I will also just keep talking without the benefit of the slides.
And while you do that, one question came to mind. What comments can you provide regarding other legal nonprofit organizations that are being retained by school districts to develop policies that appear to be deliberately discriminatory in nature?
We are certainly seeing policies proposed at school boards across the state, restricting the rights of students based on gender identity in the context of sports, of student records, and gender identity expression in those records, and how it's recorded by schools and tracked and really scrutinized by schools, as well as restricting bathroom access based on sex assigned at birth. all of those are very problematic and illegal under Title IX and I believe, under the PHRA, because of the clear prohibition on discrimination based on gender identity. So, however, those policies are coming to school boards. That is unhelpful and actually really harmful for students. And we, when talking with parents who contact ELC with concerns, when they see these types of things presenting at their school board, some of the things we talk with them about are scrutinizing and trying to urge their school board to scrutinize who's proposing such policies. What is the agenda or purpose, the mission of those organizations or actors? Are they really trying to serve the interests of all students that attend any particular school district? And what implications could come from policies that are violating students' rights, that are open to legal challenge, and indeed, therefore, open the school district to legal liability and expenses from those legal challenges.
Thank you. And I'm seeing two more questions, but again, I don't want to interrupt your presentation. If you want to continue to speak until we can get those slides, or we can provide them after, or I can ask those questions that were just added.
I think maybe with the time that we've got, I can talk through them and we'll, provide the slides after. Unfortunately, I can promise you the slides aren't super exciting. It's more text as a reference for folks. So it's probably you're not missing much, not seeing the slides and just hearing me talk through it. So let me get through some of these because I think it might answer some of the questions. And we'll try to pause again before the 2:00 mark. So when we're thinking about issues presented in schools and classrooms for students based on gender identity, we really want to orient ourselves in this foundational truth that gender identity is a deeply rooted element of someone's identity. And the sincerity of one's gender identity, like one's religious belief, is not to be disputed and should be generally presumed or easily established when it arises as an issue in some procedure or context. So really, school districts must accept and respect a student's assertion of their gender identity, where the student expresses that at school or where there's other evidence that it's a sincerely held part of their core identity. And as I mentioned, that is how we have for a long time dealt with religious beliefs, which is another core piece of one's identity. Regarding sports participation, there are, of course, many benefits of playing sports associated with schools. There's higher test scores, higher rates of school completion. It teaches teamwork and leadership skills and belonging, connectedness to that school community, and bans to prohibit students from playing based on their gender identity sometimes are claimed to, quote unquote, protect girls, cisgender girls, they mean. And it's important to, debunk that as having no basis in research. There's a CDC study that shows no negative impact on the participation of girls in school sports in a number of states that have implemented inclusive athletics policies. And really, those sexist stereotypes about how girl athletes should look or play are very obvious examples of that kind of gender identity policing and discrimination, and promotes that kind of body policing that is harmful to everyone, and certainly also most harmful to Black girls who are faced with discrimination based on, white ideals of femininity in lots of contexts. But that sports issue was not covered in the 2024 rule. There was, as you mentioned, I might remember from my slide earlier, a separate rule proposed about the participation of kids in sports. That rule received comments, but has not been a final rule issued yet. what was proposed is that schools would not be permitted to adopt or apply a one-size-fits-all policy that categorically bans trans students from participating in teams consistent with their gender identity. There'd have to be a particular assessment based on each sport, each level of competition, each grade or education level. And the criteria can't be premised on a disapproval of trans students or a desire to harm a particular student. It has to, in fact, be minimizing harms and providing opportunities for all students to participate. That issue of sports participation is, of course, in the courts, in federal courts across the country. The closest case on point here in Third Circuit, we don't have a sports case. The Third Circuit is the appellate level court in the federal system that controls Pennsylvania. I would refer to Boyertown case, where it was a bathroom case, but there's very clear language that discomfort of cisgender students is not an acceptable reason to deny equitable access. And there's no violation of cisgender students' privacy rights, for example, to have to share space with trans students. So the slide will have a number of cases from other jurisdictions and some specifics about those. We also look, of course, to the U.S. Supreme Court. I should have started with this, that in 2020 addressed an issue of a transgender person's discrimination in the employment context and found that discrimination on the basis of gender identity for a trans person violates Title VII, which is the parallel to Title IX in the employment context. And courts have long analyzed Title IX consistent with Title VII. So it's really instructive that the U.S. Supreme Court found discrimination for trans folks to violate Title VII in that context. And in the school context, 4 times in the last 5 years, the U.S. Supreme Court has declined to review cases that challenge school policies that support trans students. So the context there for non-lawyers is that, you get a decision below that affirms the rights of trans students, and it's challenged to the U.S. Supreme Court by somebody saying that's not the right decision, it should go the other way. The U.S. Supreme Court has the choice to take a case or not. So in all of these cases, they've said, no, we're not going to take that case, which means they're letting stand the decision below that supported trans students' rights. In the context of bathroom and locker room access, we do have, as I mentioned, a case in the Third Circuit out of the Boyertown School District way back in 2018. The Third Circuit rejected arguments that a school policy protecting trans students' equal access violated other students' rights. And there are consistent decisions out of our other kind of regional district federal courts in Pennsylvania, out of the Middle District, out of the Western District as well, and indeed across the country, all circuit courts, except for the 11th Circuit, have found in bathroom cases supporting the rights of trans students to use the bathroom aligned with their gender identity. There's also a slide that you'll get about a number of OCR decisions that enforcing agency OCR in their complaint process has also provided decisions about students' bathroom access rights. In the context of privacy and school records, we look at this at a few different angles. Students do have a right to privacy in their medical information, which includes their sex and gender identity. We get some assertions sometimes that parents might think FERPA, the Family Educational Rights and Privacy Act, which gives parents some rights to education records. They think that requires notice to parents about any changes in students' records. That's not true. There's no requirement under FERPA to affirmatively notify parents about anything. It just provides access rights to a parent to look at their child's records. There are some challenges working through the courts now about a parent's assertion that the school has to notify them for their consent or permission before using a different name or pronoun that their child requests in school. And this is coming out of some schools that have affirming policies that say we recognize a student's privacy rights, we recognize their rights to gender expression, and if they identify to us that they're using this name and pronoun, we're going to respect that and apply it in our school interactions. There still, as I said, challenges in the Pennsylvania context in our courts. A lot of these cases have standing problems, which means that the people who bring the case don't actually have a legally recognized stake in this claim. They're not, their rights are not under threat or being challenged in the way that they bring the case. But the weight of legal authority on these issues across the country doesn't support a requirement that a school has to obtain parent consent before upholding their non-discrimination obligation and affirming students' gender identity in school. And courts that have directly considered this issue look at a balancing interest in the parent's right to information and an individualized assessment of any potential harm that a student might face if their parents are notified and it's not safe and not affirming space for that child in that home. There's also cases in this context relevant in the Third Circuit, certainly that the right of parents is not absolute in a school context. There are scenarios and contexts where schools decide certain things and carry out their own separate legal obligations. One thing is super clear, I should flag in this context, that schools may not require the provision of documents to, quote, prove a student's sex for enrollment or activities. We've seen that in some recent revisions to school policies, and that's not accurate under state law. I'm looking at the time. The other piece I should flag under name and pronoun issues is that again, in the employment context, which is considered kind of parallel and persuasively when thinking about the school context, there are a number of cases that have found that intentionally and persistently misgendering using the wrong name and pronoun constitutes sex-based harassment and creates a hostile environment. So that would certainly be persuasive in the school context as well. And that is reconfirmed by the 2024 rule that looks at, as I say, specific contexts for any harassment claims. The other piece is some assertions we've seen in some schools where a public K-12 teacher says that they do not want to or refuse based on their own beliefs to use a student's identified name and pronoun. That's analyzed under, it could be a couple of different contexts, but addressing students in class is part of a teacher's job. So there's a canon of cases under Garcetti about that kind of context. And those cases show that there's no right concerning classroom management. So you can't disregard school instructions and school non-discrimination policy because you want to discriminate against particular students as a public K-12 teacher. And it's not considered compelled speech, quote unquote, because the employer, the school, can insist on a lawful message of non-discrimination. And again, as I mentioned before, the courts have been clear here in the Third Circuit that the school has a compelling interest and responsibility to protect students from discrimination. I have a final slide that includes ELC resources and contact information and a number of links to relevant fact sheets on these topic areas. And so that'll all be provided by email as well. I'm so sorry about the technical difficulties, not being able to share slides in this last section.
Not a problem at all, Attorney Moon. I'm just gonna check. I know we are at the 2 o'clock mark, but there's a lot of information to cover in such a short amount of time, and you did a fantastic job touching on, all of the touch points that have come up, at least in our work. So I thank you for putting such a comprehensive presentation together. With that, there were 2 other questions that did come up. The one, which I believe you did touch upon, but it is David Moore had asked a second question. Do the changes from the U.S. Department of Education that apply to students by Title IX rules also protect faculty and staff from discrimination based on the protected classes? I believe you touched on that with Title
That's a
VII.
great question. And teachers and staff in schools is not ELC's area of expertise. So sorry, I didn't really include that in the presentation, but Title IX applies to everybody in the school context. So for sure, staff and teachers as well. And I think there are other organizations that have, more information about that than ELC would, not being our focus area.
Thank you. And the last question, and I apologize, I don't have the asker. Oh, I do. Wendy Davis asked, pertaining to school records, do schools have to use a student's legal name?
Another good question that we get often. It's not so straightforward. And I think the question to ask is for what purpose? Because it's clear that when interacting with students, the obligation is to use the identified name and pronoun to respect someone's gender identity and not discriminate. And so that does include changing, their name as it appears on a Google Classroom that's going to show up as visible for everyone. And, roll call, the name that's identified publicly. All sorts of those like regular interactions between staff and students throughout the day. And in fact, the Pennsylvania Department of Education includes in their like PIMS manual about the data reporting system that schools have to use, explicit instructions about how to change a student's name and pronouns when reporting to federal and state. There's options for how to respect students' rights in that process.
Wonderful, thank you. And as you had said, all great questions. So we are 2 minutes after. I just want to thank everyone that remained with us. I know we went a little bit over time, but again, very pertinent and relevant information being shared. As a reminder, just for the PHRC, we do have 2 upcoming Beloved Community Tour stops. I believe they've been shared here in the chat, so please take a look at those. Our next Lunch and Learn session is scheduled for October 15th from 1 p.m. to 2 p.m. The topic is language equity for social change. And if you're not already doing so, please follow our social pages. I believe we're on all platforms at this point in time to stay up to date on relevant information and everything that we're doing here at the PHRC. On behalf of our executive director, who gives his regards and apologies for being unable to attend, we thank you here at the PHRC, just ELCPA. You all are constant partners in this fight for social justice, and we appreciate all of you immensely. So thank you so much, Attorney Moon.
I'm so happy to be here. Thanks, everyone.